Just after 10 a.m. Eastern Time today, a development quietly unfolded inside the federal justice system that immediately altered the balance of several ongoing criminal cases. There were no cameras, no public statements, and no political theater. What changed everything was a document, a proffer letter dated February 3, 2026, confirming that Melania Trump's legal team is now actively negotiating immunity with federal prosecutors. This was not rumor. It was not sourced from anonymous chatter or partisan leaks. It was a formal legal document spelling out exactly what prosecutors want before they agree to any protection. And the level of detail in that letter tells you something important. This is not a casual conversation. This is the kind of negotiation that only happens when prosecutors believe they are close to locking in intent. Her grand jury testimony is scheduled for next Friday, 7 days from now. That timing is deliberate. Immunity talks at this stage do not begin unless prosecutors already have evidence strong enough to test the witness. They are not hoping she fills gaps. They are checking alignment. The proffer letter identifies 5 specific areas where prosecutors believe she has first-hand knowledge. These are not abstract topics. They are narrow, defined windows into alleged criminal conduct. First, January 6 planning discussions inside the White House residence between December 15, 2020 and January 5, 2021. Prosecutors believe meetings occurred in private living spaces where plans related to certification delays were discussed. These were not private marital conversations. Staff, aides, and advisors were present. That distinction matters. Conversations like that are not protected. Second, classified document handling at Mar-a-Lago. Prosecutors want testimony about storage rooms, access permissions, and internal discussions once requests came from the National Archives. Who knew? Who directed? Who decided what stayed and what moved? Third, financial transactions. Bank records show Melania Trump listed as a signatory on accounts that received payments from foreign sources. Prosecutors want explanations. Why those funds moved? Who authorized them? What they were connected to. Fourth, obstruction conversations following federal subpoenas issued in May 2022. The letter references discussions she allegedly overheard about which materials should be produced and which should not. That is not hindsight. That is alleged contemporaneous conduct. Fifth, witness influence. Prosecutors believe she observed conversations about discouraging cooperation by others. Again, not private marital speech, but operational discussions involving third parties. The immunity being negotiated is extensive. It includes use immunity and derivative use immunity. In simple terms, her testimony cannot be used against her, and evidence derived from it cannot either. This is the strongest protection federal prosecutors offer, but it is conditional. Absolute truthfulness is required. If she lies, the deal dies. If she withholds, it dies. Perjury is not covered. Immunity is not forgiveness. It is a truth for protection contract. Many people assume spousal privilege blocks this entirely. It does not. Spousal privilege does not cover observations made in business meetings. It does not apply to conversations held with others present. And it does not protect acts taken to further a crime. Prosecutors built this proffer specifically around those limits. Now consider the defendant's position. His defenses rely on distance. Distance from intent. Distance from coordination. Distance from decision-making. Spousal testimony erases that distance. A spouse hears explanations without lawyers present, sees decisions when cameras are off, understands context no outsider ever will. Jurors recognize that instinctively. They understand what it costs to testify against a spouse. Marriage, reputation, stability. When jurors see that cost paid, credibility shifts. This is not about loyalty or betrayal. It is about leverage. Prosecutors do not offer immunity unless they already have evidence to verify every claim. That is the safeguard. Today, just after 10 a.m., this case stopped being theoretical. The inner circle cracked procedurally, not publicly. And once that happens, the legal process does not slow down for politics. The real significance of these immunity negotiations is not emotional. It is structural. Federal criminal cases succeed or fail on intent. Outcomes can be documented. Transactions can be traced. But intent requires someone who was inside the room when decisions were made. That is what prosecutors are positioning to obtain. The proffer letter makes clear that Melania Trump is not being treated as a neutral observer. She is being treated as a witness with potential exposure. Exposure creates leverage. Leverage creates cooperation. Prosecutors already have financial records bearing her signature. They already have digital communications connected to her devices. They already have access logs and surveillance placing her at specific meetings. Immunity is being offered not because evidence is missing, but because her testimony can confirm it. This follows a long-standing Department of Justice playbook. First, collect documents. Second, secure testimony from peripheral actors. Third, apply pressure to those closest to the core. Only then do prosecutors offer immunity to high-value insiders. History supports this approach. In major corporate fraud cases, spouses have cooperated when confronted with their own potential charges. In organized crime prosecutions, family members have broken silence when prison became a real possibility. The pattern repeats. Loyalty holds until consequences become personal. Defense teams will argue she is acting to protect herself. That argument may land emotionally, but legally, it fails when evidence corroborates testimony. Jurors are instructed to evaluate consistency, not motivation. Recordings do not reinterpret themselves. Messages do not soften with explanation. This is why spousal testimony carries unique weight. Access is unmatched. Credibility is assumed unless disproven. And character defenses collapse instantly when contradicted from inside the family. The political impact is already leaking into view. Republican lawmakers are privately acknowledging what they hesitate to say publicly. Anonymous comments suggest concern about defending against testimony that cannot be dismissed as partisan. A spouse under oath is not a talking point. It is a problem. Party leadership understands the calendar. Grand jury testimony next week. Possible indictments within weeks. Trials moving toward spring or summer. Primary season unfolding at the same time. Candidates will be asked a simple question repeatedly. Do you support someone whose own spouse testified under oath to criminal conduct? That is not a messaging issue. It is existential. From a prosecutorial standpoint, the objective is precision. Precision of intent. Precision of coordination. Precision of responsibility. Immunity negotiations are how those elements are locked into the record. The safeguards are severe. If she lies, immunity evaporates. Prosecutors can pursue original charges plus perjury. That threat ensures alignment with truth, not loyalty. This is why immunity is misunderstood by the public. It is not kindness. It is enforcement. It is the system choosing the most consequential target. The defendant remains publicly defiant. That is expected. What matters is what happens under oath, behind closed doors, in transcripts that cannot be spun away. Grand juries do not care about rallies. Judges do not weigh political narratives. They weigh admissible evidence. Once testimony enters the record, it reshapes everything. Charging decisions, trial posture, sentencing exposure, negotiation leverage. Today, just after 10 a.m., the system signaled it had reached that stage. Negotiations active. Terms specific. Deadlines real. If the agreement is finalized by midweek, testimony proceeds next Friday. If testimony proceeds, the effects will be immediate. Additional indictments may follow quickly. Defense strategies will narrow. Public confidence will diverge from private calculations. This is not chaos. It is procedure working as designed. When evidence accumulates, pressure concentrates. When pressure concentrates, cooperation emerges. And when cooperation comes from inside the inner circle, cases stop drifting and start concluding. What happens next will not be dramatic. It will be methodical. Filings, hearings, transcripts, rulings. But today morning marked a turning point. Not because of headlines, but because documents were signed, negotiations entered, and testimony scheduled. Once that machinery moves, it does not reverse. From here forward, facts decide. That is where this case now stands.